Hello, everyone, and welcome to the October Research Keys to Real Estate podcast. I'm your host, Mary Schuster. Our guest today is Lauren Campisi from Hinshaw Culbertson LLP. Lauren is a knowledgeable and talented attorney who specializes in the field of consumer financial services. We'll link her full bio in today's show notes, and trust me when I tell you, her experience is impressive. I first heard Lauren during a panel discussion last year at the American Bar Association's Business Law Fall Meeting, where her wisdom and thoughtful analysis were unmissable. And back then, I knew we would want her on the podcast today to help lay the foundations for a Supreme Court of the United States opinion due out any moment now. So we're going fully nerdy on today's episode because there are some cases that have the real potential to impact most of what you do in a day's work. So we called in an expert to get you briefed and ready to deal with whatever comes our way this summer. And please enjoy my conversation with Lauren Campisi. The presenting sponsor of the Keys to Real Estate podcast is RamQuest. RamQuest fosters a customer-first culture built around an unwavering commitment to provide solutions that don't just meet, but exceed expectations. RamQuest's newest title and settlement production solution, Horizon, delivers unparalleled efficiency, robust features, and scalability to ensure you have tools to boost productivity and elevate performance like never before. Horizon streamlines your operation with secure 24/7 access, automatic updates, and all the power that only the cloud can offer. Plus, Horizon offers a direct connection to the industry's most extensive network of service providers and partners. Experience Horizon for yourself when you visit ramquest.com. And now, please enjoy the show. Lauren, welcome to Keys to Real Estate. We're thrilled to have you, and we have a lot of ground to cover today. So are you ready to get to it?
Let's do it.
Great. Thanks for being here. So at the top, we should start probably by saying that for logistical reasons, we're recording on May the 10th. And this episode is scheduled to release in early June, which is around the same time period when the Supreme Court tends to issue their big opinions. So there is a chance that we might have opinions out on the two cases we're discussing today before the episode becomes available. So I want listeners to know that there'll be plenty of coverage of the opinions and their aftermath, including and especially in our October research publications. But what I wanted us to do today, Lauren, is to refresh in the minds of our audience why the cases of Loper Bright and Relentless Inc., cases that have fact patterns that involve fishing companies, not banks or title companies or anything even adjacent to the real estate industry. Why is it so important for people who work with federal banking regulations and really nearly any federal regulation should care about this? And I know that's a big chunk to lead off, Lauren, but why do people who work in the real estate, title insurance, and lending industries need to be very dialed into these cases about fishing boats?
Definitely. So short answer is that anyone who works in this space knows that even though we are subject to a host of different federal laws, there are lots of ambiguities in those laws, and they're subject to different interpretations by lots of very smart people, in whether they're in industry or judges having different interpretations. So this case, the Loper Bright case, really focuses on whether when federal statutes are challenged, whether courts have to defer to an agency's interpretation of those laws. And it really calls into question a longstanding judicial doctrine that from 1984 in a case called Chevron. So we refer to that judicial doctrine as Chevron Deference because it really established what we've been using for the last 40 plus years to answer that question of does a court have to defer to the agency's interpretation of a federal statute? And of course, that concept didn't start in the 80s. We have decisions that pre-existed Chevron. And what we've seen over the last probably 80 years is an evolution of these concepts of when is it appropriate to defer, when do courts have no obligation to defer to an agency's interpretation? And as you might suspect, as political winds have changed over time, we have differences in opinions on how much judicial deference there should be to agency interpretations.
And interestingly, I've heard some discussion about the fact that Chevron coming into being as a concept in the 80s was kind of a largely conservative concept that believed the subject matter experts in the agencies themselves were, sort of far more capable of handling certain issues than were the courts, who did not have the expertise and who at the time were more liberal. And so the idea was, well, let's put this over here. And does the makeup of today's court and the makeup of maybe today's administration or administrations of late have anything to do, in your opinion, of why we're anticipating a change to that level of Chevron deference?
Yeah, it's a great question. So you're absolutely right. Back in 1984, the intention, so this was a judicial doctrine that was championed by then Justice Scalia, that was intended to conceptually move power from courts, arguably, to administrative agencies that were in a period of deregulation. Exactly as you mentioned, the concept was that courts, who at that time were perceived to be more activist and liberal, would have to defer to the federal agencies that were charged with interpreting and enforcing the federal statutes, and that was a period of deregulation. What happened, though, of course, as we've seen very vividly over the last several years, with changes in administrations, you see different approaches to the federal agencies. And so we've moved from periods of deregulation back to periods of activism. And in those more activist periods, agencies realize that judicial deference to their interpretations can be a significant tool to accomplish policy objectives. And that, of course, has been of significant concern to conservatives, who I think made it pretty explicit their intention to revisit or roll back these concepts, because the principles of Chevron deference are not arguably sort of enshrined in clear constitutional or other statutory law. It is a judicial concept. And so there's significant criticism that there really is no rationale articulated for Chevron deference, that it's been misused or misapplied. It's been eroded over time. And now we see the Supreme Court accept petitions for cert to revisit this concept in general. So we may have a continued slow erosion. Others are more clear that they would like to see Chevron deference be overruled in its entirety.
And I've heard a lot of people discuss as well the fact that we arguably had a very different Congress in the 80s that was either more clear with some of the laws they were writing, or were actually writing laws. You might not want to get that cheeky about it, but I have heard some discussion that the function of Congress is, it's really the goal is to sort of rebalance the checks and balances, right, that have gotten, in the views of some, a little out of whack.
So to your point, we have sort of this interesting combination of a phishing case raising really fundamental separation of powers, constitutional concepts, non-delegation of duty, of whether Congress can effectively delegate legislative powers to an administrative agency, judicial deference concepts, really fundamental pillars of federal government and how it's intended to function, coming up for resolution, we think, in this case about whether government monitors should be paid by the fishing vessel or someone else.
Right, exactly. And we'll let some others kind of continue down that path of their discussion and sort of the Madisonian vision of all this. But for our listeners now, what I'd like to do is kind of drill down and say, okay, why is this relevant to us? Let's name a few of the agencies that we're talking about when we talk about, is it all federal consumer financial services regulators? Let's throw out some of those alphabet soups of agencies that listeners will be familiar with.
Sure. So in our world, definitely very familiar with the actions of, more recently, the Consumer Financial Protection Bureau, the CFPB, but also prudential banking regulators, the Office of the Comptroller of the Currency, the OCC, the Federal Deposit Insurance Corporation, FDIC, NCUA for credit unions, the Federal Trade Commission, HUD. Those are just agencies we deal with routinely, but we really are talking about all agencies. And so agency at issue in this case, again, a phishing agency outside of our consumer financial protection world, but the case would impact all federal agencies, not specific to any one industry.
Yeah, so let's drill it down one step lower. I'm going to shout out some names of acts that our listeners interact with every day, and you can tell me if they would be involved in these opinions that come out. RESPA.
Yes, and we'll talk about that, I'm sure, soon, but absolutely, RESPA decisions have involved significant issues of interpretation of RESPA itself. Previously, HUD's interpretation, lots of statements of policy on key provisions of RESPA, like Section 8, and then more recently, again, with the CFPB's interpretations as well. So RESPA very much in focus and potentially impacted by whatever the Supreme Court may decide.
Okay, how about HMDA?
Same, very much the same. So again, we have a combination of agencies historically, but yeah, HMDA, a statute where more recently the CFPB has certainly interpreted, enforced, provided guidance with respect to the scope and meaning of that law.
How about HOPA?
Absolutely. I think the theme here is going to be yes.
Yes.
The nuanced question might be, though, is all of these different very significant federal statutes. And that's kind of the underpinnings of Chevron and the cases that preceded Chevron and succeeded Chevron are that in a complex, highly regulated space, there's no way for Congress to craft legislation so clear and explicit and providing all the granular detail that it requires no further interpretation by an agency. And because of that, there has been historically significant deference to agencies, whether it's the Federal Reserve Board or more recently the CFPB. It's grounded sort of in this appreciation that the agency is more of the expert in that industry and space and is in a better position to interpret any ambiguities in the statute. That's not limitless, and even the liberal justices in the Supreme Court today have made that clear in more recent cases like Kaiser. But the concept is that the federal agency that's specifically tasked by Congress to carry out its intentions with respect to a particular statute is in a better position to interpret and fill in those ambiguities. And before we had Chevron, maybe getting ahead of myself now, but before the Chevron decision was promulgated in 84, we had a series of other types of deference concepts. So the one that is thrown around more frequently and probably better known is a case involving Skidmore. In the concept of Skidmore deference, it's essentially deferring to an agency interpretation, not completely, but in a way that it's persuasive. So it's giving deference to that interpretation, but the agency still has to be persuasive in whatever the interpretation might be. Then from there, we get into, frankly, much stronger deference concepts. Within this space, a case from 1980, Ford versus Mulholland, interpreting very technical provisions of Regulation Z, which implements the Truth in Lending Act. And there, basically, the Supreme Court would have created an even higher, or did create an even higher threshold, understanding that the Federal Reserve Board was the expert in the space, promulgated Regulation Z, highly technical space. Essentially, it would defer, or the standard is to defer to the Fed unless basically the interpretation was demonstrably unreasonable, I think was the language from Mulholland, but a really high bar with significant deference to the agency. That standard is softened a bit in Chevron. Reasonability standard will go through the steps, I'm sure, and then further weakened and eroded over time, which I do think is a reflection of the unfortunate divisiveness of our political structure today and a sense of real politicization of federal agencies, courts even, and wild swings between administrations.
Well, and it gets down to so many granular things, like you were talking about with Reg Z and TILA. This could impact our definition of what is an interest rate, exactly what are the components of an interest rate, and what is a finance charge, and preemption questions of federal issues vis-a-vis state law and fair lending protections. I mean, it's sort of everything. Is that an overstatement?
Well, what I would say, so maybe the better way to answer that is it could be everything. I mean, certainly to some extent, you might argue that almost every federal statute that governed the mortgage lending or consumer credit space in general arguably has some ambiguity baked within it. Lots of examples of active current fights or differences in interpretation today. But if we think about that judicial deference framework that we have today based on the Chevron decision, to even have Chevron deference apply, first requirement is that Congress delegated interpretive authority basically to an agency, and the agency exercised that authority. That's further refined in a subsequent decision that we'll talk about. But first is agency, basically one agency has interpretive authority and it exercised it. If there are multiple agencies that potentially have authority, there's not the same level of deference afforded. But if we have a single agency, they exercise their deference. The first, and that's what might be referred to by some as sort of step zero. But then step one is the federal statute ambiguous? And that allows courts to disagree. And if there isn't an ambiguity in the statute, that is the end of the deference consideration. And then the court undertakes its own interpretation and analysis, and we don't move on to step two. If there is ambiguity, the second step then is to determine whether essentially the agency's interpretation is reasonable. Not that the court agrees with it, you still could have a difference of interpretation, but as long as that agency's interpretation is reasonable, then the court is bound to defer to it. To your point, it is potentially every statute, but not statutes that are unambiguous, or not to unambiguous provisions within every statute that governs this space.
Well, it was interesting. My colleague Elizabeth and I attended the oral arguments for these cases, and the degree to which it was discussed how the lower courts still really rely on Chevron and seem to really like them, and Congress arguably has crafted legislation for 40 years now with Chevron kind of running in the background, kind of shoring things up. And again, it was how a lot of these definitions and things that we all work with today were brought about under that construct. And you also mentioned that Chevron has been eroding. Its popularity, obviously, at the Supreme Court anyway, has been eroding. And so we've brought in some new kinds of, you mentioned some historical deference, but the Supreme Court seems to be really leaning more towards a major questions doctrine philosophy, which maybe we should talk about. I don't know your thoughts on that. I'd love to hear them.
Yes, we talked a little about, we had Skidmore deference from the 40s, other concepts, another case called Seminole Rock. That was about whether courts are bound to defer to an agency's interpretation of its own regulations, not the statute itself. Ford versus Mulholland, an example of an even higher threshold and level of deference to an agency. Then we have Chevron in 84. Then we have another decision called AUER, that also kind of touches on Seminole Rock and deference to agency interpretations of their own regulations. Then we have a decision called Meade. Meade arguably imposes or further sort of restricts when Chevron deference applies and focuses on whether the agency's interpretation has the force of law. More to talk about there, but we'll keep going. Then we had that decision in Kaiser, primarily authored by Justice Kagan. So a fractured opinion. We have Chief Justice Roberts joining in only parts of that decision, but arguably kind of rewriting those concepts from Seminole Rock and AUER on deference to an agency's interpretation of its own reg. And then more recently, too, to your point, further erosion, where a court will consider not just step zero, not just step one, not just step two, but then also, is this an issue of such political or economic significance that Congress would not have essentially delegated this authority to the agency if it's not express in the statute itself? So more recently, multiple examples of the major questions doctrine being used by the Supreme Court to not employ Chevron deference and not defer to the agency's interpretation. I think the additional complexity to all of these issues are picking up again on that need concept and also tied in a bit to these major questions issues of, in our space in particular, very complex. Lawyers like me have spent 20 years basically devoted to this practice, and still can't answer definitively these complicated questions where there's significant ambiguity and differences of opinion by different judges, different circuits, different regulators, lots of confusion. But we have these situations where Congress enacts a statute, is delegating some authority to an agency. Agency is acting in a more clear path through the Administrative Procedures Act by rulemaking, very clear. But of course, we've seen more recently lots of ways where agencies, particularly the CFPB, have acted without promulgating a formal regulation, and questions about whether that carries the force of law. On the one hand, it seems to, in certain instances, from a Congressional Review Act perspective, but then in other instances, it arguably does not. In fact, by the agency's own regulation, adopting the interagency guidance, that supervisory guidance does not carry the force of law. It cannot be the basis for supervisory criticism, cannot be the basis for enforcement action, I guess, unless it is. But lots of confusion around when is something really a legal obligation versus an informal interpretation. The judicial branch is tasked all the way back to Marbury versus Madison with interpreting laws. When is it appropriate for the judicial branch to defer to an agency interpretation, particularly when the enabling federal statute might be very bare bones, very incomplete? And how much should it matter if the agency has gone through the APA process versus promulgated something less than that, whether it's revisions to an exam manual or an advisory opinion,
A
or
blog post,
supervisory highlight, a blog post, an enforcement action. It creates a lot of confusion.
Yes.
And I think the other kind of punchline here, which happy to defer to your questions and get there in another way. I guess the way I think about this from a policy perspective, very much biased by the work that I do trying to help people comply. My clients want the answers, and I want to be able to help them find those answers, but there isn't always an easy, clear, clean answer. Lots of complexity, not just in ambiguities of a federal statute or a regulation or an interpretation, but of course also our federalist structure of overlap between federal and state laws, how much weight to give competing judicial interpretations, lots of confusion. And sadly, at the end of the day, no one wins in that situation. Ambiguity and confusion and complexity, ultimately, from my perspective, is borne by consumers. Cost has to be passed somewhere. Someone is bearing that cost. And sadly, it often ends up being consumers who end up carrying the freight.
You're very, very right about that. We agree. We in this listening community agree. You just have to hedge against so many unknown interpretations that it gets very expensive. And yes, you're right; those costs get passed down, and it's maybe not the most efficient way. Support for today's episode is provided by October Research. October Research provides national coverage of case law, news, regulatory updates, and competitive business strategies critical for sustaining an innovative and compliant real estate business operation. Our portfolio publications offer independent and unbiased information that helps you stay educated and informed on what matters most to your business. So visit octoberresearch.com to learn more about our portfolio of real estate publications, sign up for free email news, educational webinars, and premier industry events for thought leaders. Knowledge, the competitive advantage. Let's, if you will, hate to ask to read tea leaves. If you want to be in the prediction business, that would be great. But before you do that, let's talk about some of the lanes that we could see this ruling go, some of the options, whether or not you want to weigh in on what you think's most likely is okay too.
Sure. So I guess we can think extremes and then somewhere in the middle. One extreme would be Supreme Court just completely overrules Chevron, and we have no more judicial deference to agency interpretations. I guess another extreme would be Chevron is upheld and nothing changes. In my mind, I think both of those scenarios are unlikely. I do think we're likely somewhere in the middle, which I guess the past precedent would show that if the Supreme Court had an interest in taking this case, it likely wasn't to leave things status quo. Right. So something is changing or likely to change. And if we look at the evolution of the interpretations, particularly more recent interpretations with essentially this composition of the Supreme Court, you would expect there to be less deference. And that can happen through different ways. It can be through more direction and clarity on sort of that step zero. When is it appropriate to even consider Chevron deference or a deference to an agency interpretation period? Does it, what does that mean, force of law? And does it need to be something more explicit from Congress? That's a possibility. Possibility that there's more direction from the Supreme Court on how courts are supposed to use tools of statutory construction to determine whether the statute is ambiguous. That's a possibility. Another possibility would be more direction around step two conceptually, or we could have more steps. That is maybe less likely. I think that the opponents of Chevron deference have been really vocal about wanting it to be overturned, like Justice Gorsuch or Thomas, have signaled or perhaps reiterated Justice Scalia's original intent for the rule. The stated intent was that it was supposed to be more simple. It was supposed to be more clear and easy to apply. And the criticism has been, or a criticism has been, over time, it's gotten more complicated and not simple. So I sort of doubt, I guess, that we're going to see a more complicated concept or number of steps to apply Chevron deference. We could see more explicit direction with respect to concepts of major questions doctrine. That is the way that academics and scholars refer to what the Supreme Court has said when it chooses not to apply Chevron deference, but it isn't a formalized concept that the Supreme Court itself has referred to as a judicial doctrine. So we may see more direction from that perspective. But I think the bottom line is what we're anticipating is preserving more authority for the judicial branch to clearly exercise its role and not completely defer to an agency interpretation is, from my perspective, most likely. If we were to see a world where we have no more Chevron deference, and not just Chevron deference, but no more deference to agency interpretations, of course, that can be incredibly disruptive because we are more likely to have uncertainty with respect to what these laws mean and how to comply with them. And then, of course, it opens it up to competing interpretations that further complicate efforts to comply. So you could end up with different interpretations in different jurisdictions, whether that's different, different judicial districts, circuits, or perhaps even more discreetly differences in interpretations by judges within districts. Worst case scenario, I guess, in that way.
Yeah. No, so watching this court is always very interesting, and at least as interesting as the conservatives versus the more liberal and how they talk. I have the most fun watching the sort of the consequentialists. And I got to tell you, on this one, I'm really rooting for that group to be really thinking past just the doctrine itself and its application, which I know gets kind of muddy and tricky, because you're right. One of the things I'm concerned about is if it's pared too far back, and they seem to really kind of hover around Kaiser. A lot of questions had kept coming back to Kaiser in those oral arguments. But my fear is that if we have to relitigate, example, what is an interest rate? What are the elements, the allowable elements of an interest rate or a finance charge? And those get litigated out, to your point, across the country in different jurisdiction, different districts. We could have court splits, and how in that space and time and space. And I'm not trying to be a, the sky is falling person. I'm just an operations minded person. And I think about these things pragmatically. How is a national lender supposed to issue disclosures across all of these different interpretations? I mean, when you start thinking about it operationally, it gets real scary.
It does. It is incredibly complicated and scary in lots of different ways. So scary in that, yes, there will be risk to all of the different players in our industry in their normal business operations, to the extent that they're either relying on an agency interpretation that is disregarded and no longer something you can rely upon, or whether you're relying on a judicial interpretation that is overruled or disagreed with in a different jurisdiction. It can be very, very complicated. The other kind of potential consequences of this, we already talked about who bears the ultimate cost, but the risk in, to your point, if there's a different interpretation of what interest means for purposes of exportation or otherwise, that obviously, to the extent that lenders have relied upon agency interpretations, built their operations, lent trillions of dollars based on those interpretations, and they're no longer valid, does that expose those lenders immediately to private litigation? I would hope that the agency that promulgated those past interpretations would not enforce a competing interpretation, but you're immediately exposed to private litigation potentially, even if you ultimately win. Of course, the expense of defending yourself against actions can cripple companies. And so, again, like thinking about litigation risk, in addition to that, just the complexity of thinking about how to comply and compliance costs, all of those further potentially inhibit competition. And that, again, reduces availability of credit and ultimately, arguably, it hurts consumers. Because if there are fewer people competing in the marketplace, fewer opportunities, fewer competitors to benefit consumers in the ways that competition does, consumers hurt at the end of the day.
Well, so as we right now are poised, waiting, what that we haven't yet talked about today do you think is important for listeners to have in their minds as they, as this ruling comes out? Again, as we said, we're going to help keep everybody informed, and we're going to help them pivot to whatever the new reality is. But what are some important things before that we haven't talked about yet that people should be focused on?
Yeah. So one I would say is, one, I will be hopeful that we don't end up in a world of chaos. That would be nice and helpful. World is complicated enough today. It would be helpful if we could just have a little more certainty or clarity in whose interpretation of laws to follow. Hopeful that that's the case. What I would say too is there are all kinds of other far too complicated to discuss right now, but judicial concepts, legal concepts that hopefully would mitigate risks of, falling further into chaos. So other concepts, for example, about stare decisis. So even if we may no longer have deference to an agency interpretation, it doesn't necessarily mean that the way that case was decided however many years ago is no longer reliable. either because the court undertook a Chevron analysis, but said I would have found the same regardless of the agency's interpretation, or just based on fundamental principles of stare decisis. Hopefully, we wouldn't end up in a world where everything is sort of up to be relitigated. There are some other really interesting concepts of sort of the interplay between the Administrative Procedures Act and these concepts. And so there is a process to challenge agency regulations. And so to the extent that here we're left with a world where an agency interpretation that has the force of law is required to go through an APA rulemaking process, and then the APA rulemaking process has a path to challenge that rule and an associated statute of limitations to challenge that rule, there are some additional potential tools that can help from, again, sort of mass chaos. And then, I guess I would say too, although not overly optimistic, Congress obviously divided government and very small margins, difficult to see legislation pass, but there are a number of very potentially consequential decisions that can come out from the Supreme Court, and it may force Congress to give us more of a legislative solution to some of these issues, whether that's the funding and constitutionality issues of the Bureau, more clarity with respect to key laws that we need more specificity to, or we need revisions to remove ambiguities, to make our economy and our markets function more properly and not create economic turmoil. Hopeful that we would be able to see some leadership from our government in those ways too. But again, I am not. I'm not a fatalist. Certainly, I'm very much a middle child. So I guess my natural inclination is to go somewhere right in the middle. But I would expect that we're going to see some further narrowing and harnessing in of judicial deference concepts. Hopeful, though, that we don't see a situation where we're just left with no concept of deference or no path forward, no framework from the court. I just find it hard to expect that.
Well, from your lips to God's ears. I know that is a lot of the intention, is to yes, have the agencies comport themselves a little bit differently, but also it's mostly to sort of cattle prod Congress to kind of get back in the game, right? And I'm fully supportive of that concept. I'm not sure in today's right now minute world whether that cattle prod will get the reaction we're looking for or not. Yes, only time will tell. And who knew that administrative law was going to have its moment right now and on these issues? But we're going to need you and experts to help us get through this, because I think we all agree we're not quite sure what the change is going to be. But I've not talked with anyone who expects no change. And so that's part of the reason we wanted to introduce you to our audience today, because when this happens, when this change does come about, operationally, practically, people are going to have to tune to it, and they're going to need help being guided through that. And so we wanted to make sure that they understood the fundamentals in place, and have an idea of how to act when this all happens, because things could change pretty quickly, right? Depending on how the opinion comes out.
Yes. So all speculative. Don't have my magic 8 ball with me, but yes. I mean, depending on what the decision says, it could have. So Supreme Court decisions don't have sort of compliance periods like rulemakings do. So it will say whatever it says. It will set the tone of the law of the land on how courts are expected to treat agency interpretations, and we'll move forward. We'll digest. We'll read however many pages we need to read. We'll think through it, and we'll find a path forward of what that means for this industry and every regulated industry, which again, I think just sort of highlights again, how evolution of our government, of all of these agencies, the world that we live in, much more complex. It's hard to get a regulation now from an agency that's not 1,000 pages. Part of that is going through all of those processes of responding to every comment and demonstrating cost-benefit analysis and all the other steps that the agency have to take. But we have so many rules, so much, so many different competing issuances and attempts to provide guidance and clarity. So a lot to sort through, but yes, we'll see whatever the Supreme Court says, we'll digest, figure out the next step forward. And I'm sure it won't be the end of sort of these interesting judicial decisions, testing all the ambiguities in the world that we live in. That will continue, undoubtedly.
Well, we can't thank you enough for lending us your expertise today. I know your life is about to get very busy, so I hope you're, drinking your Gatorade and doing your yoga, because you're going to need a lot of strength and stamina if these cases come down the way many of us think they will. So, as I said, we promise to help keep everyone informed and compliant with whatever lies ahead. And Lauren, you've been an invaluable contributor to that mission today. We will call upon you in the future, if that's okay, as we all work together to figure out what this new world will look like and how we're going to all operate in it together.
Definitely. So I'd be remiss if I didn't say that, particularly in this podcast, that the way that these cases connect, and the one thing to really keep your eye on is we have the Townstone decision before the Seventh Circuit. So in Townstone, of course, issue was an interpretation of ECOA, the Equal Credit Opportunity Act, and Regulation B, originally promulgated by the Fed, over time through Dodd-Frank, transferred to the CFPB. In that case, it's all about what the meaning of applicant essentially means, and whether the Fed originally and then now the Bureau interpretation that ECOA applies not just to people who have actually applied for credit, but also to prospective applicants. And at the district court level, the defendant, Townstone, won their motion to dismiss on that legal issue, that the Fed's interpretation and the CFPB's interpretation was not entitled to deference. So we didn't even get to step two. So step zero of Chevron was, it was very clear that the Fed and then the Bureau were authorized by Congress to interpret and promulgate rules under ECOA. But the district court found that the statute was unambiguous, that it only restricted or the protections only applied to actual applicants, not to prospective applicants. And so it didn't get to whether the Fed and the CFPB's interpretation was reasonable under step two. It stopped only on step one. So it is, one of the most significant cases right now that turns in large part on whether the agency's decades-old interpretation is entitled to deference at all. And we'll see whether the Seventh Circuit agrees. And I'm sure regardless of what happens, that's probably not the end of that story either.
Oh, well, then I'll put on a plug. We will have, Rich Horn has agreed to come do an episode with us and discuss all of that when we get that. So we're all kind of waiting with bated breath on that one as well. There's so much right now.
Definitely. Yeah. And I mean, so just really quickly too, other examples. So we've talked about, I think you were referencing the Smiley decision from 1994. That was about the meaning of interest for purpose of interest rate exportation authority under the National Bank Act and deference to the OCC's interpretation. But we have a number of issues under RESPA. So we have whether courts should defer to HUD's old statements of policy under Section 8. I was involved years ago in the Freeman decision that went up to the Supreme Court on whether unearned undivided fees violate Section 8. And we were successful all the way from the Eastern District of Louisiana to the Fifth Circuit to the Supreme Court that no, RESPA does not apply or does not prohibit. Section 8 has no bearing on unearned undivided fees. That case was about discount points. But lots of agency interpretations on RESPA. And of course, too, more issues under Section 8 with respect to MSAs and the Bureau's guidance and informal guidance, or is it formal or informal? So lots of issues, very, very germane to this particular segment of the consumer finance industry that could have significant impact on whatever the Supreme Court may decide.
We'll make sure our listening audience knows how to reach you, because I have a feeling everybody's going to need some help getting through this.
I appreciate it.
Thank you so much.
And thank you. Really appreciate the opportunity. This was my first podcast. It was fun, and look forward to another one.
Thanks again, Lauren. We will look forward to hearing your analysis of these opinions when they're issued, and your advice about how we can compliantly move forward in whatever the new post-Chevron world looks like. And by the way, listeners, did you notice that Lauren said this impacts every regulated industry? So these opinions won't just change your work life, they'll impact your experiences as a consumer too. Lauren's email address is linked in today's show notes should you want to reach her. For more resources and information, RESPA News is our publication to follow along for real-time breaking news and updates as the rest of this story continues to evolve. RESPA News editor, Elizabeth Childers, would love to know what questions you have, so drop her a note if you'd like, or if you prefer, just stick close by and stay current with her reporting. If you've missed our coverage so far, visit the RESPA News archive to get caught up. Also, for color and background on the oral arguments, visit the archives of our blog at octoberresearch.com/blog. We publish a new blog each Tuesday, but you can find information about these cases in our posts from January 30th, 2024, also February 6th, 13th, and 20th. Thank you for joining us today. We'll keep bringing the guests and topics that help you successfully hold your keys to real estate. And until next time, I'm Mary Schuster for October Research, where knowledge is the competitive advantage.